Well, joining me now to go over the first day of testimony in the Ontario government's court case against the federal carbon tax is Errol Mendes. He's a professor of law and a professor of constitutional law at the University of Ottawa. First of all, thanks for coming in.
You're very welcome.
Okay, before we go any further, let's set up how this whole legal case is going to unfold in the court. Today we heard the Ontario government's case.
Right.
How's it all going to unfold?
Well, as you know, then you'll have the response by the federal government, and then you'll have the interveners coming in. Usually, firstly, the provinces who've asked to be interveners, including the provinces who've actually already participated in the Saskatchewan Court of Appeal, and then you'll have quite a lot of other interveners, NGOs and others who are wanting to put their view of what the issues are.
First Nations groups, environmental groups and all that.
That's right.
Okay, take us through the main thrust. What was the main thrust of the argument by the Ontario government, by Doug Ford's government, against the carbon tax? What did we hear in court today?
Well, the Ontario government is arguing that the main legal basis for which the federal government is putting forward is so-called national framework for greenhouse gas emissions, carbon tax in other words, it cannot stand under what the federal government claims is their authority under the national concern part of the Peace, Order and Good Government Clause in the preamble to our Constitution. Now, there's a lot there in terms of unpacking it, but essentially, in a nutshell, for those who are not lawyers, it's basically when the federal government, when the UK Parliament was setting up our Constitution, they divided up powers between the provinces and the federal government, and each had very specific powers, and essentially the role of the Supreme Court of Canada was to police those powers. However, in the preamble to the Constitution, there is this overarching power given to the federal government to make laws to further the peace, order and good government of Canada. And part of that over the decades have included things such as the national concern test, which if the federal government can show that there is an area of activity which the provinces by themselves are unable to regulate, and the issue has become a national concern, and the issue is very specific, it's very distinct and is indivisible, then the federal government can pass laws in relation to that.
And the Ontario lawyers, as I watched, spent a good part of the morning arguing that climate change is not a national concern, that provinces can't deal with themselves. They don't need an overarching federal initiative that they can deal. I think the Ontario lawyer said it in his first few minutes. He said, no, we can go about addressing climate change ourselves.
Right, and what was fascinating to me, listening to this, even though it was very difficult to because it went in and out in terms of the feed, was the questions from the judges. And some of the questions really try to get them to answer, in effect, what the federal government may be pursuing tomorrow or the day after, which is one of the judges, for example, said, well, what happens where a province decides to do nothing? Are you saying then where the Canada, as a sovereign country, has signed on to the Paris Accords, has committed to reducing greenhouse gas emissions by a certain standard? They've committed, it's a legal obligation. And you're now saying that as long as the provinces can do this themselves, everything's going to be okay? And then the answer that the lawyer had struggled to give was, what happens where one province says, we don't want to do anything? So that goes to the rebut that the federal government's going to give, that where there is an inability of the provinces to work together to reach that level, which is required by the Paris Treaty, or they're not doing enough, then the federal government can come in and have a national framework to ensure that we're meeting the Paris Accord.
Which is ironic, because that's the federal government's political argument for the 4 provinces that have been given this backstop.
Right.
The political argument was that you didn't meet our standards, and so we're intervening in Ontario and Manitoba and New Brunswick. Basically, the other argument I heard from the Ontario government was about taxes.
Right.
Was that this is not an acceptable tax.
Right.
What's that argument?
Right. Well, this is a fascinating argument both by Saskatchewan and by Ontario. And I'll give you the Saskatchewan too, because it shows you how complex this whole area can get. In the Saskatchewan Court of Appeal, the Saskatchewan government said at first, yes, you're right, this could be a tax. But then immediately said, but it's an illegal tax. Why? Because they claimed under, you don't need to know the details, but under Section 53 of the Constitution and 125 of the Constitution, there is this phrase, no taxation without representation. And if you have structured the carbon tax to depend on what each province is doing, you no longer have a unified tax across the country.
You're discriminating between provinces.
You're discriminating, and therefore it's no longer just a constitutional tax, it's an unconstitutional tax. So they turn the argument on its head. Now, Ontario is actually doing something slightly different. They're saying, actually, we don't think it's a tax, it's a regulatory charge. And by the way, we don't think it's a constitutional regulatory charge because, you're giving the money back to the provinces. So what sort of regulation are you organizing here? Whereas the federal government's going to say, well, that's the whole point of it, because one reason why you have the charge is to affect human behavior.
But if I heard properly, Ontario argued that the importance is it's all going into general revenues, and so if it's something that's specific to change people's behavior, then it should go somehow towards that and not just into the general coffers of the state. And they sort of seem to suggest that makes it an improper tax or an improper regulatory charge.
Well, that's one of their arguments, and so basically what they're saying is that because you're giving the money back mainly through tax rebates, that it's no longer linked into the purpose of the regulation. Whereas the federal government's going to come back, I'm sure, tomorrow and say, well, that's the whole point, is to affect behavior. And so part of the regulation is affecting behavior, because once you give people the choice, say at the gas pump, to pay that extra price, or maybe shift to electronic cars or take the transit, etc., you're actually implementing the regulation. So it's interesting how both the Saskatchewan and Ontario are basically flipping the arguments of the federal government on its head, and the federal government is immediately flipping it back.
Okay, so you have today in Ontario, you have the Ontario government saying, A, it's not constitutional, it's beyond your powers, and B, it's not a proper tax.
Right.
Tomorrow, the federal government will say, you've already alluded to some of it.
Right. So tomorrow the federal government is going to reinforce, their main argument will be on the national concern test. And they actually have structured it in a way which is reinforcing some of the arguments they heard back in Saskatchewan.
So climate change is serious.
Right. And first of all, climate change is getting even more serious as the days and the months and the years go by. Secondly, they also stress something which they may have not stressed enough in the Saskatchewan Court of Appeal, which is, yes, sure, the provinces can regulate certain aspects of greenhouse gases within your jurisdiction, but we are focusing on what they call the cumulative impact of greenhouse gases, which goes beyond what you're doing within your own jurisdiction. But when you accumulate the different greenhouse gases, much of which is actually going beyond the province, beyond into other provinces and into the atmosphere. That's where the federal concern comes in.
I'm going to ask you the difficult question, and it's very much a prognosticator question or evaluative question, and that is, do the provinces, Saskatchewan, Ontario, have strong cases, or do you agree with many legal experts in saying that no, the federal government has a very strong case?
The federal government, I think, has a very strong case if they emphasize what they actually perhaps didn't strongly emphasize in the Saskatchewan Court of Appeal, which is this focus on the cumulative impact of greenhouse gases, where you're not talking about, yes, all the provinces have the jurisdiction to regulate to a certain extent, but when you're talking about the cumulative amount of greenhouse gases which goes beyond just one province and which actually goes into the atmosphere, there is no other jurisdiction which can regulate that other than the federal government.
Of course, this is all on the legal side. If, for example, the provinces were to lose their case and federal initiative be upheld, then this also plays out politically. I mean, this is very ideological.
Right, and some would say, especially with the Ontario reference to the Court of Appeal, it is primarily ideological, because essentially when you look at what the government has done, for example, in its omnibus bill, it even slipped in this very strange and potentially, in my view, potentially unconstitutional measure to impose stickers on retail owners for the gas pumps, where they're ordering these stickers on the gas pumps, which says at present you have this amount of charge extra, and then in 2022 you're going to have an even more. Well, I mean, to some extent, there's a good argument to be made that's a violation of freedom of expression. And so it's part of this larger approach to put in a political strategy on this whole area of greenhouse gases and carbon taxes.
Well, I want to thank you for walking through the legal side of it all. Thank you very much for coming in.
You're very welcome.